Thank you, Madam Chairman. Thank you and welcome to each of the witnesses for being here today. I think the topic of this hearing is exceptionally important, both as a substantive policy matter, but also more importantly as a matter of constitutional law and the threat we are seeing to our constitutional system. I want to begin on substance. It is my view that the modern Democratic Party, and to a significant extent, union leadership, are actively working contrary to the interest of working men and women in this country and union members. Indeed, in January 2013, in a Rasmussen poll, 90% of union members said that the reduction of illegal immigration was important to them. Likewise, Zogby in 2010, polling union members found 72% of union members said Americans can fill open jobs. My question for you, Ms. Schuler, is the AFL-CIO is here testifying in favor of work authorizations for some 5 million people who are in this country illegally. That testimony is directly contrary to the strong interest and preferences of your millions of members. And how does leadership reconcile acting against the interests and preferences of those millions of union members?
Well, I will say that polls are, I guess, subject to interpretation, and we've seen that since this last November, right? We can find a poll that will support anything, essentially, but I think the journey that we've been on in the labor movement with regard to union members and the immigration issue has been a long journey, and we've had a very diverse debate and diverse set of opinions over time that has evolved. And I will say that we have a very robust executive council that represents, as I said earlier, 12.5 million working men and women, and we have broad agreement that this policy that we're talking about, the President's memorandum, will benefit workers because of the impact that a low-wage economy of people working in the shadows, people who are afraid to speak out and advocate for themselves, the impact that that has on all working people.
Well, thank you, Ms. Schuler. I would note that while some opinion polls are open to interpretation, the election we had in November was unambiguous. President Obama rightly said his policies were on the ballot across the country, and the American people overwhelmingly rejected amnesty, and I feel confident that union members across the country would be astonished to know that union bosses are more interested in loyalty to the Democratic Party than the union bosses are in standing up for the working men and women who have been struggling mightily the last 6 years. I'd like to now turn, Professor Eastman, to the constitutional and legal questions. And you and I have known each other a couple decades now. As troubling as this is on substance, and I think this is very troubling on substance, the broader constitutional issue is even more pernicious in my view. Now, the President has attempted to justify unilaterally setting aside federal immigration laws under the aegis of prosecutorial discretion. Prosecutorial discretion has long been part of what a prosecutor does. Prosecutors decide to allocate resources to one crime or another. But what the President has done here is far broader than prosecutorial discretion. The President has not simply said we are going to focus our prosecutorial resources on the most violent illegal immigrants. What the President has said is something qualitatively different, which is that the administration will issue work authorizations to some 5 million people who are here illegally. Now, there's no authorization in law for those work authorizations. The administration is, for all intents and purposes, counterfeiting immigration documents, because federal immigration law says quite clearly that individuals who have come to this country illegally are not eligible to work. My question to you as a constitutional scholar, are you aware of any interpretation of prosecutorial discretion that allows the federal government to issue essentially get-out-of-jail-free cards, work authorizations that purport on their face to authorize 5 million people to violate the express terms of federal law?
No, Senator, I don't. And let me take the example that Professor Schroeder gave a moment ago about an administration that chooses to provide less enforcement resources or priority to the environmental law. Let's make it categorical, like this one is. Say if you produce less than 10 million tons of pollutants a year, we're not going to prosecute you. That would be pushing the envelope on prosecutorial discretion, but it still wouldn't have gone as far as this is. To go as far as what happened here, we would be giving a license to continue to permit, to pollute. We would give pollution permits, pollution validation licenses for 3 years, renewable infinitely, in order to match what the president has done here. I've never seen anything like it, certainly not under the guise of prosecutorial discretion. No Supreme Court decision has even hinted that the prosecutorial discretion authority can be used so far.
And there's nothing in federal law or the Constitution that authorizes it?
Nothing so whatsoever.
Thank you very much.
Since the chair has allowed some latitude in terms of the questioning and the time limits, I would like to ask Professor Schroeder if you would like to respond to the questions by Senator Cruz.
Thank you very much, Senator.
On the extent of the limits of prosecutorial discretion.
Yes, I quite agree that work authorization cannot be done under enforcement discretion. And if you read the OLC memorandum, they don't think so either. They think the employment authorization documents can only be issued because of a provision of the statute that allows those documents to be issued if aliens fall into categories acknowledged by law or granted by the Attorney General. You then look to a Code of Federal Regulations provision that's been on the books for years, and you find that one of the enumerated categories are people who have received deferred action. So that's the legal basis for the work authorization, and I quite agree, it's not prosecutorial discretion.
Professor Schroeder, if I might follow up on that. You're right, the OLC memo grasps one portion of the statute, which is a definitional portion that makes reference to an authorization by the Attorney General. And yet, under ordinary principles of statutory interpretation, we don't interpret one element of a statute to make the remainder of the statute superfluous. Does it strike you as a reasonable legal interpretation that the meaning of this one phrase in a definitional section gives the Attorney General the ability to authorize any person on earth illegally in this country or who wants to come to this country to work? And if that's the case, what is the purpose of the entire remainder of the statute if it simply could be rewritten, the Attorney General may grant authorization to anybody to work, notwithstanding any other provision of federal law?
No, I quite agree the Attorney General couldn't grant that to anyone. I believe that his discretion is limited by the terms of the Code of Federal Regulation, which specify categories. It doesn't have a provision in it that says, and anybody the Attorney General cares to grant documents to can also be granted documents.
So let me make sure I understand you. You say because the CFR, in turn, the regs seek to expand on that and say deferred adjudication, that the Attorney General could say we are deferring adjudication to 7 billion people, everyone illegally in this country and everyone who might seek to come to this country. We will defer adjudication to all of them.
No, he couldn't do that either. But now you're back in prosecutorial discretion land.
But
that would be an abuse of prosecutorial discretion under the language and analysis of the Office of Legal Counsel opinion.
But how is 5 million not an abuse?
Because there is a humanitarian concern that is reflected in congressional policy embodied in the statute, that is reflected in the choice that the the Department of Homeland Security has made to grant deferred action to those individuals. Once they're in the deferred action category, they become eligible for work authorization pursuant to the statute and the regs that I've just referenced.
Professor Schroeder, I recognize that you agree substantively with the policy of granting amnesty, and reasonable minds can disagree on that.
Senator, if I may, I agree legally with the policy.
Well, my question was legally. Your answer was as a humanitarian matter, you support it.
No, excuse me if I misspoke. I apologize. The analysis of the OLC opinion requires that deferred action decisions be consonant with policies that are reflected in the existing immigration laws. They therefore needed to find a justifiable humanitarian concern, which they did in the terms of family unification for the classes of individuals that they're talking about, namely people who have one member of the family as a legal citizen or legal permanent resident here. And that's the justification. You may not like it. You may think it is overweighted by other concerns like the kinds that Professor Ting has expressed. But there's nothing in the statute that precludes that action. That action is consonant with the stated policy. And under the system of separation of powers that we have, it's up to the current administration to make the policy call, with which people can disagree, as to how to implement the statute that gives the president that discretionary flexibility. That's the full dress review of the argument.
Your suggestion is that this executive authority is authorized because it's consistent with the will of Congress? Is that really what you're saying?
No, I'm saying that executive discretion is authorized. Pardon me.
Okay. The chair believes that she has given